Hey, Brent Bowyer here from ADAM. So let's talk divorce. A typical question that we get when someone is facing a divorce is, does my wife really get half? Is my wife going to get half of the property when we get divorced? Well, that can depend on a few different factors, and as lawyers like to say, it depends. But we can tell you what it does depend on. So first of all, we'd want to know, is there a prenuptial agreement? If there's a prenuptial agreement, as long as it's valid, in Michigan, they typically are valid. It depends on a whole nother analysis. But in general, if there's a prenuptial agreement and it's valid, that will dictate who gets what, and that's usually going to turn into your wife not getting half of everything because there are assets that were protected by the prenuptial agreement. If there's no prenup, which is often the case, then we're looking at, okay, who gets what? We have to decide what's marital property and what is separate property. So Michigan is what's called a dual property state. We're not community property. Community property would be like California, for example. So in Michigan, we use dual property as the analysis for dividing assets in a divorce case. So what that means is we have to look at what's marital property, what's separate property. So marital property is going to be anything acquired during the marriage that was not inherited and something that we acquired during the marriage. So for example, if I've been married 10 years and I have a 401k, I've been putting money into that account for 10 years, my wife could expect to get half of that in the divorce case, even though it's only in my separate name. So defining marital property, defining separate property isn't tied necessarily to whose name is on the property. An example we often give is you could be married for 10 years and your wife never gets put on anything for some reason. She's not on the title to the house, not on the bank accounts. You still might be splitting everything up depending on what's marital and what's separate. So if we go back to the idea of a 401k, it's possible that I would be dividing half of that 401k with my wife in the divorce, even though she never contributed to it and her name's not on it. Now, if I had a 401k for 15 years and I've only been married for 5, I could say, well, I had some money in there before the marriage. That portion is premarital, and then the rest is marital. So if I have 50,000 in there and I had 20,000 at the time we got married, I could say, well, I get the 20 and then we'll split the other 30 grand 15 each. I end up with 35, my wife ends up with 15. So it's not half and half in that scenario. Could be the same thing with a house. Sometimes you had a house before you got married, you move into it, you keep it for a while. You might still be living in that same house. It was really a premarital asset. And then you could say, well, it's not really right that my wife will get half of it. I owned it before the marriage. So that's the analysis in general that we're looking at, is what's marital property, what's separate property. Well, so to get more into defining what separate property is, so separate property could be property I owned before the marriage. That's one example. It could also be property that I've inherited during the marriage. So if I get an inheritance, I get money from a relative that has died, and I put it in a separate bank account and I keep it in my separate name. I go to get divorced, I have a good chance of protecting that and saying I get to keep the entire account. My wife does not get half of that account in the divorce. So that's an example of separate property. It can also be gifts. Gifts can get a little tricky when it comes to houses, as in, like, my parents gave us money for a down payment, but did they really give it to me or did they give it to both of us? But if there's a gift, a relative gives you $30,000 over some period of time and you keep it separate and it's in a separate bank account, you could potentially be able to protect it at the time that you're getting divorced. So Michigan looks at this analysis of what's marital property, what's separate property. But in general, if I've been married 30 years, we're probably dividing everything I have unless I have an inheritance or something that's been separated. And by dividing property, you're looking at real estate, retirement accounts, investments, savings, vehicles, furniture, could be anything, is all loosely kind of defined as property. And then we have to look at what was marital and what was separate. So that's the general idea on does my wife get half, and how we answer that question when we're looking at things with the client. You could even be dividing things like pensions, which I know are not as prevalent as they once were, but if they're out there, it's possible to divide a pension by court order. Same thing with 401k, 403b, defined contribution plans, also can be divided by court order. So it's good to keep in mind, if we look at it and we get to the conclusion that yes, your wife will get half of it, it wouldn't mean you have to cash it out or try to borrow against it. If it's a retirement account, we can move some portion of the money. If it's half, then so be it. We can move that to your wife, put it in her name, and help you figure all that out. So it's important to get advice early on in the process. get a sense of what assets can I protect, what am I going to have to divide, and what's the process of dividing those assets, because that's also a question with this process too. So I hope that helps. Thanks.